The purpose of this recording is academic and is for a university assignment only. Hi Mrs. Hogan, thank you for coming in. I've collated some business structure information I believe to be relevant as per your instructions from the other day. I have two recommendations for you today. First is to keep trading as a sole trader, and second is to transfer to a proprietary company. The reason I have recommended you continue trading as a sole trader is your desire to keep your business structure simple and informal. Being a sole trader is the least formal business structure there is. There are no legislative requirements to follow for the organisation or ongoing management of your business. You, as a sole trader, are able to make your business decisions as you see fit, keeping in mind the usual contract, tort and consumer protection laws still apply. As a sole trader, there are no reporting requirements, no requirement for special financial arrangements either. The business and yourself, the owner, are one and the same person. This is where unlimited liability comes into discussion. The other day I explained that as a sole trader, your assets and the business assets are one and the same. If the business is sued, you are liable for the debt as you own what the business owns. This is where I will raise a second recommendation I have prepared. Only raise this option as you provided for future expansion in your instructions. Your business fits the requirements provided by the legislation to be registered as a proprietary company. Now, trading as a company is more formal and structured than trading as a sole trader, and there are some structural and reporting obligations. There is Commonwealth legislation that governs companies, the Corporations Act 2001. It provides for how proprietary companies are registered, what qualifies as a proprietary company, their obligations to report, and how they are structured. That's just to cover some of the Act. The most significant difference, to begin with, the Act provides a company is its own legal entity, separate from its directors and shareholders. It owns its own assets and liabilities. This is further supported by the common law decision in Solomon's case. In this case, the court ruled that a company is a separate legal entity distinct from shareholders and directors, and essentially established what is now known as a corporate veil. This decision is relevant to the advice, as Solomon & Co. was essentially a single director company. Being a single director company means some of the rules of the Corporations Act would not apply to your business if you were to register. Your business, under the legislation, Section 113, qualifies to register as a small private proprietary company, and as mentioned above, you would be the single director. The corporate veil is a reason I raise the option of becoming a proprietary company. Essentially, the corporate veil separates you and your business as two different entities. Section 124 of the Act gives your company the legal capacity and powers of an individual. This means the company is responsible for its own assets and liabilities. It can sue and be sued. This is significant because it limits the risk to your personal assets, such as your home. To register a proprietary company can be a lengthy process, as provided for by Section 117 of the Act. An application has to be made to ASIC to register the company, and further provided by Section 117 are all the requirements of the information required by ASIC in the application. Another option available is to purchase what they call a shelf company and have it transferred to you. Section 601, capital A, capital J of the Act provides an application can be made to ASIC in the prescribed form. To transfer a company must be supported by a special resolution and a signed statement by the directors. A shelf company is a registered company that has never traded. Many accounting firms and law firms have them available to clients as it cuts down the registration time. The Act provides provisions for the internal management of the company. However, as a single director company, you are not required to enforce the replaceable rules as per Section 135. Instead, Section 136 provides for the creation and adoption of the company's own constitution for internal management. It should be noted in the case of Shuttleworth and Cox Brothers & Co., the court established the rule that a company cannot be prevented from amending its constitution or replaceable rules if the correct procedure is followed. In this case, the directors gave themselves a clause in the constitution as directors for life. The company was able to follow the legislation and alter this clause. As for financial reporting obligations, I have not prepared any advice relating to taxation requirements of companies, only on the requirements of the Act. Part 2, capital M.3 of the Act sets the obligations for financial reports and directors' reports. Section 292 subsection 2 specifically covers the small proprietary companies. This section states that the reports are only required to be prepared if directed under Section 293 or 294. Those sections relate to a request by a shareholder who has 5% or more, or ASIC, and further, if the company was controlled by a foreign company for all or part of the year. Essentially, the reports required by your small proprietary business your company would be minimal. You mentioned in your instructions that you prefer the flexibility of the informal structure because you're able to cease trading if you so desired. As a company, there is more of a process involved for wanting to deregister. This is covered by Section 601 A, voluntary deregistration. Under subsection 1 of that section, you as the director are able to lodge the application with ASIC, and subsection 2 provides all the requirements that you would need to meet for the application. These include that all members of the company agree to the deregistration, that the company is not carrying on business, and that the company's assets are worth less than $1,000, and the company has paid all fees and penalties payable under this Act, and the company has no outstanding liabilities, and that the company is not a party to any legal proceedings. The option of registering as a company is formal and structured, but provides great options for the expansion of your business and the security of your personal assets. Remaining as a sole trader provides you the ease and flexibility you are seeking with no legislative requirements. Thank you for attending today, Mrs. Hogan. Please consider the recommendations and contact myself if you have any questions or inquiries. Thank you.